Hello, everyone. I'm Rob Harkavy. I'm the acting editor of CDR magazine, and it is my pleasure to welcome you all to this webinar entitled ESG Disclosures Inviting Class Action Attention, which I think we'll all agree is one of the most topical and fastest growing legal issues exercising the minds of business, the legal profession, and for that matter, the general public right now. I know we've got a pretty big turnout from all over the world, so let me just say thank you and pay tribute to those of you who, because of time zone differences, have given up your private time to join us today. Thanks ever so much. Now, we've put together a truly eminent panel for you today, with BRG's Dr. Robin Cantor joining us from Washington, DC, and she'll be in the chair. Robin is a vastly experienced economist, a focus on science and tech throughout her career, and she's a highly sought after expert witness that has, when I was doing her bio, it looks to me like she's lent her expertise to everything from analysing statistical models to settlements involving claims for asbestos and, of course, issues relating to the environment. In fact, she's the president of the Women's Council of Energy and the Environment. So well done. Now, Robin is joined by two panelists from here in Europe. First off, I'd like to welcome Sonja Hoffmann. She's a partner with White and Case in Frankfurt, Germany. And I think it's fair to say that in Germany, progress towards a vigorous class action regime has been fairly slow. But despite that, she has got a notable back catalogue of collective redress proceedings behind her, not least in the ESG universe. And she has a particular focus on human rights, supply chain, and climate change disputes. And next to the EU member state, which perhaps, which definitely has embraced collective proceedings more than any other. And I'm delighted to welcome Bart-Adriaan de Ruijter. He's a corporate litigation partner with CMS in the Netherlands and a member of the firm's ESG Global Task Force. There's really not a lot that he doesn't know about climate change and energy-related disputes with it, which is just as well, because that's obviously precisely why we're here. Now, a little bit of housekeeping. If any questions spring to mind, I'm sure you wouldn't anyway, but please don't interrupt. Just use the Q&A function here on Zoom, and the chair will try to get to as many as she can in due course. So that's enough from me. Let's crack on. And I'm handing you back now to Dr. Robin Cantor, who's going to take it from here. Thank you.
Okay, well, thank you very much, Rob, and thank you to GLG for arranging this and allowing us the opportunity to talk about these very important ESG issues. We're going to cover a number of topics today. It's going to be quite a full scope, and we're going to be making sure that we leave a little time so that we can get to some questions. Please, again, use the Q&A function. And the focus is going to be mainly on Europe, but many of these same issues apply to the US. And I am just delighted that I have Bart and Sonja here to inform us. And the first thing that I would like to address is, please give us some sense of the regimes within your own countries. And so I'm going to start with Bart, and this should be brief, just a brief discussion of what's going on in the Netherlands. So, Bart.
Yeah, thank you, Robin. The Netherlands is one of the front runners in ESG litigation with the Urgenda case against the Dutch state, a corporate demand action to reduce climate impact. And next to that, the Shell case, which I'll elaborate later in further detail. Furthermore, a lot of greenwashing claims collectively and by NGOs. And next to this ESG specific kind of litigation, we have a very strong class action climate in the Netherlands with new laws since 2020, which and also possible to claim damages as a collective group, which is of course a good source for future litigation. So the infrastructure is quite good for collective claims, and the judges are ready for that. So that's something to take into consideration.
Okay, and Sonja, how about Germany?
Yeah, maybe just to give you a brief overview of the German situation, it's really different from the Netherlands. So in contrast to the Netherlands, we have a very underdeveloped system of a collective redress mechanism. And Germany is and has been all times quite reserved when it comes to collective redress. So in the past, we had only a few possibilities to bring collective actions, mainly with regard to the capital markets law, with unfair competition, or in connection with invalid terms and conditions, but that was it. In 2018, when the diesel scandal had a big play in Germany, Germany established the first model declaratory action, which means that consumers could bring a collective action, but only claim for a declaratory judgment, which means in the end that individual claims have to be brought afterwards to receive any kind of damage or redress. So this is not a very sharp sword. And therefore, currently, what's going on by way of the implementation of the EU Directive of Representative Actions, Germany is establishing its first redress mechanism where consumers can claim for damages. But this is not enforced yet. It will be enforced soon. But at least from my perspective, and to be honest, Germany does this only because it has to do it because of the EU regulations. It has to do it because of efficiency aspects with regard to the mass claims around the diesel cases, which overflooded the courts. And of course, to be competitive in the market because we are far behind the Netherlands. And but it doesn't really fit to the German legal system. And this is the big challenge for us in the coming years, in particular, also with regard to ESG regimes, which is, I mean, a really massive trend in Germany. And we will see the connection between ESG litigation and collective redress coming up soon in Germany. And this will be really a challenge for courts to handle all this. And I think I'm really curious what Bart will mention with regard to the topics we will discuss within the next hours, because, I mean, they are very much more modern than we are at the moment.
Yeah, there is an interesting contrast between the Netherlands and Germany. And I think the first topic we're going to start with is decarbonization and climate change, because, you know, again, much of ESG has been driven by that. How has the class action litigation affected companies with large greenhouse gas emissions? And I'm going to start with Bart, who I think is going to describe one of the major decisions for us.
Thank you, Robin. I think you're referring to the big Shell case of 2021. That case is really a turning point in history, because it's the first case in which
I think we also have a slide there, right? So you may want to go to the slide 4.
It's possible. But this is how. The NGOs look at it. You see below happy faces, and that was because this is a turning point in history for NGOs, because this was the first time that multinationals held accountable for dangerous climate change. In principle, the Shell was ordered to reduce its greenhouse gas emissions by 2030. And that was based on an open tort in combination with the Paris Climate Agreement, on basis of its own policies, what its self-inflicted obligations, and the human rights, open human rights, mainly the human rights articles 2 and 8 of the European Convention of the Protection of Human Rights. And next to that, the UN guiding principles on business and human rights, which inflict some kind of duty of care to reduce dangerous climate change as the company itself, and so also some kind of duty of care towards its supply chain. And this case is now used as crowbar against other multinationals in the Netherlands by NGOs. They say, please comply, or otherwise you get the stick of litigation. And you see that all kinds of NGOs now are checking climate plans of all multinationals to look if they are in line with the Paris Climate Agreement, looking at our greenhouse gas emissions from a global perspective.
Okay, and Sonja, so give us a contrast to that particular perspective.
Not really a contrast. In Germany, of course, the Shell decision was very much discussed as well, and it has a lot of impact in Germany, because all the German NGOs, they joined forces and also filed lawsuits before the German courts, not as a class actions, but the NGOs filed maybe together with one or two activists lawsuit, for example, against VW, BMW, Daimler, Wintershall, and they claimed that there is a violation of their constitutional rights and their
and we have a slide for that one too, so let's advance the slides.
As well as their freedom rights, which are infringed if these companies won't reduce their their greenhouse gas emissions, and stop selling combustion engines, cars with combustion engines, until a certain year, 2030 or so. In Germany, however, the jurisdiction is different than in the Netherlands, because all the claims has been dismissed, at least in the first instance. Why did the courts dismiss the actions? It was mainly because they said there must be a balancing of the fundamental rights of the company and a balancing of the individual rights, freedom rights of the claimants. And the German courts state that as long as the companies are in line with the legal requirements and the laws which the government and the legislative said, so then it's okay, yeah. And a company cannot be so a company cannot be forced to do more by a civil court than by the state. So in this was the main reason why all the courts in Germany dismissed the action so far, because they thought there are no particular cases where one claimant can claim extraordinary circumstances which might overweight the interest of the companies which are in line with the German laws. And so all these actions are in the end dismissed. Maybe you can also mention all the diesel cases which are currently ongoing in Germany as part of the climate change litigation, but this is a big dispute whether you call it climate change dispute or not. But last but not least, I would like to highlight one special case which really caught attention from all over Europe and even from the United States. And maybe we move over to the next slide. It's the RWE case, which is a really interesting case. What's this case about? A Peruvian farmer filed a lawsuit in Germany alleging that RWE, due to having contributed to climate change by emitting greenhouse gases, is responsible for the melting of the mountain glaciers in Peru. And he based his action on tort law. In the first instance, the regional court rejected the claim because he said there is no sufficient causal link between the greenhouse gas emissions of RWA and the melting of the glaciers in Peru, which is, from a German perspective, a reasonable judgment. But then we moved over, or the plaintiff appealed, and now the case is pending before the higher regional court of Hamm, and they took a really different approach. So they said, okay, we have to do a taking of evidence whether the greenhouse gas emissions of RWE, which is 0.47% of the global emissions, are responsible for the melting of the glaciers. And so this spring, there have been a side evidence taking in Peru. We don't know how this lawsuit will end and how the result will be, but in any way, it's really interesting because you see that also the courts in Germany have a focus on green aspects and on ESG now, and they're considering with much more attention, which they have been done so in the last few years. So, I mean, this is the most impressive case to show how Germany is developing recently.
Yeah, thank you for that. So another topic, a little bit different from the focus on decarbonization, is the greenwashing. Right, so greenwashing, where disclosures or misleading statements are made to try and enhance a company's ESG performance. And we're seeing many different types of claims show up under greenwashing. Let me start with Bart. So what are you seeing as some of the major sources of the increasing risks from greenwashing claims?
Yeah, thank you, Robin. Yeah, greenwashing is a really hot topic also in the Netherlands. Companies should be aware of that risk, and in general, you see three different types of greenwashing. It's misleading market product information for consumers. And there are all kinds of consumer protective regulations nationally and also internationally to prevent that. And we see also a lot of focus on that from the supervisory authorities to minimize the impact of greenwashing on the consumers. A big case in that respect is the KLM greenwashing claim, in which the claimant organization says that KLM is pretending to be some kind of green net zero airline, which is not the case, apparently not the case. And they are being sued for that case to amend its product information towards consumers, and perhaps also maybe later for damages, but that's not the case at this moment. Furthermore, we see misleading of the investing public, for misleading, misleading financial information towards the product investing information, and the last but not least, misleading annual financial reporting information. And that last source will increase significantly, to my opinion, because the CSRD is coming up, the Corporate Sustainability Reporting Directive, as from 2024. The first line of companies will need to comply with that, and in that CSRD, companies need to be more elaborate on their ESG actions, some kind of duty of care with regard to climate plan is that in there, and that CSRD will lead to more elaborate transparency on that respect. But you can also better control if a company is in line with it. So you can check what's standing in the annual accounts and their commitments in that respect, but you can also look what are you actually doing. So with this enhanced, NGOs or collective groups can start claims with regard to misleading annual accounts. And within the Dutch Corporate Law Society, the Corporate Litigation Society, I must say, this is being seen as one of the biggest trends for the near future, the biggest source of claims towards multinationals and its boards.
Okay, so Sonja, can you follow up a little bit and speak more to the issue of what's happening with greenwashing in manufacturers?
Yeah, so maybe I start with where greenwashing started in Germany. So I fully agree with Bart that also in Germany, greenwashing is one of the most important ESG issues. I mean, this is also due to the EU regulations, which are currently coming up as well. But where did it start in Germany? In Germany, we had a lot of greenwashing litigation in the financial industry with regard to investment funds. So we had many court proceedings where, for example, investment funds had stated that they're only investing in measurable ecological effect products, or they did not invest in coal or something else, but they could not transparent explain how they verified this information, and this is maybe which would be better in the future because of the CRSD is in place and people now know how to report, or maybe know better how to report. But all the greenwashing cases in Germany starts or rely on transparency issues in the financial industry. But this is now, there is a big turn now towards the consumer and retail industry as well as to the energy sector. We have not that prominent greenwashing cases as, for example, France has. So they are really on the forefront of this development. but I just want to illustrate one case in Germany. So maybe we show the next slide now, which is a green. Oh
It's
no,
the one-
we don't have it on a slide. Okay, that's the case. The Deutsche Umwelthilfe against Total Energies. Yes, this is it at the moment. So the Deutsche Umwelthilfe brought unfair competition lawsuit on the basis of the EUWG claiming that Total Energies used the term climate carbon neutral, which was misleading. So all we know, because this decision is not published yet, is that the Regional Court of Düsseldorf ruled in favor of the Deutsche Umwelthilfe, which means that Total Energies can no longer advertise that their fuel oil's carbon has been compensated for. So this is one of the moment ongoing cases in Germany. We know that Deutsche Umwelthilfe has brought 14 other cases against retailers, supermarket, airlines, and energy companies, but we don't see so more details because they're at the moment going on and currently ongoing, so we don't have any result yet. But we see an increase of greenwashing cases in Germany as well.
Okay, and we received a question which gets to something I think that you brought up earlier, Sonja, which with respect to the auto manufacturers and the understanding that you do need to let companies be companies. I mean, that they're supposed to be pursuing their financial interests. And there have been criticisms that much of the the ESG or the greenwashing focus or any other component of ESG might cause a conflict for companies in pursuing their optimal financial interests as opposed to pursuing some of these social objectives. So the question was, can you speak to that particular response from companies that, they must be allowed to pursue their, what they see best for their financial interest?
We saw already such case in the UK a little bit towards Shell, in which the board of Shell was held accountable for its strategy, for its long-term strategy, that it was not climate friendly in the long run. And of course, this is climate friendliness, and in the long run is of course in conflict with profit in the long with profit on the short run. So we see a conflict of interest arise between the profit and the ESG, and that's something we will touch upon later, because that's what we see in the internal sphere of the legal entities, that there is a clash between different kinds of shareholders within companies, and it also depends on in which sector you're active. But you see a clash between the shareholders, the group which want to pursue the profit on the short run, and are there in there for the short run, in comparison to maybe institutional investors who are there in for the long run. They are more focused on the ESG in the long run. I was on a presentation of the Norwegian bank this summer, and they are really focusing on the long run in all their investments. So on all their, also in their shareholder votings, they use that. So that will clash, of course, with other shareholders.
Yeah. Okay. So let me just give Sonja. Sonja, did you have any follow-up for that, or?
What I can add from my perspective is that the companies where I'm working with, of course, they follow their financial goals, but all these ESG aspects became so dominant in Germany that there is a big focus also in responsiveness, and it's a big reputation risks if the companies don't raise their ESG standards. So I don't talk about shareholder activism. This is what we're discussing later, but I'm talking about management decisions. So they are way more conscious than they have been earlier with regards to ESG topics. And of course, they would like to follow their financial goals, but they are really trying to do this in connection with an ESG conform management strategy. And in particular, what we also see a lot in Germany is that the management is, and I think this is also leading to maybe the next topic, that's the supply chain in Germany, is really establishing whole compliance departments only for this ESG topics. And I think they try to make their financial goals more in line with ESG standards.
Right.
This is what my perspective.
Yeah, so that does raise the next issue, which is about blue washing. And of course, blue washing is where you get into these unsubstantiated or misleading, socially conscious, ethical claims that might be made by companies, especially referring to the S part of ESG and getting into things like the diversity, equity, inclusion. And this is a focus that goes well beyond a product or a particular service that's being offered by the company, and actually starts to address the entire corporate governance and structure. And we do know that there are different perspectives on this, and in fact, a lot of conflict, as you just raised, over this. So Sonja, let me start with you so that we can talk about some of these issues that do attach to things like the supply chain, where there are very different perspectives.
Yeah, so absolutely. So when it comes to the S, I think Germany, the big thing in Germany is the Supply Chain Act, which came into force at the beginning of this year. So maybe we go to the next slide. Yeah, absolutely. So the German Supply Chain Act is the first hard law in Germany, aims to protect the human rights of people who produces goods here for the German market. This law has passed the parliament already 2 years ago, but they gave the companies over 2 years of implementation period before the law came in force, because this is what I mentioned before. The companies really had to build up whole compliance departments to comply with all these new regulations which we have. Needless to say, we had a lot of work to do to assist the companies to renew their code of conduct and to build up their departments. So I think this was one of the toughest tasks for the company within the last few years. And what is the key takeaway with regard to the Supply Chain Act? For companies now, this means that their supply chains now command the same attention as maybe, or for example, the financial performance. So what is the Supply Chain Act about? So it now imposes due diligence obligations on companies with regards to that they do not violate human rights standards within their supply chain. And so companies are required to, and I give you a quick overview there, establish risk management system, analyze supply chains and adopt policy statements, take preventive measures and remediating measures, establish a grievance mechanism, and of course, reporting obligations. And this all, of course, and what has this to do with class actions, to do with the rise of liability aspects, although in the area of supply chain and the human rights standards. So what has not been the case before, companies can now be liable if there is a violation of human rights at the end of the supply chain. So German companies can be sued now before the courts if such case happens that there might be any violation in one of maybe an Asian country or somewhere else on the end of the supply chain. And in contrast to that, I would just highlight one case which was decided before the Supply Chain Act came into force. Maybe we go over to the next slide. Yeah, so that the most prominent case is the KIK textile discount case in Germany. So there was a fire at a textile factory in Pakistan where more than 260 workers died. And the factory's biggest client was KIK, a German discount retailer. And in 2015, victims filed a civil action against KIK in Dortmund, seeking compensation, referring to court human rights violations in the supply chain. In 2019, the court rejected the claim based on Pakistani tort law. Maybe in particular because the limitation of the statute of limitation had expired. But however, by way of an obiter dicta, the court held that liability of KIK does not arise from a contract for the benefit of a third party or from a supply contract or code of conduct. So the action was dismissed. And this would have not been the case after the supply chain, the German Supply Chain Act is now in force. I predict this case would have been decided differently now. This more or less even holds in particular because of the upcoming CRDD, sorry, because it's the European Supply Chain Act who might come into force quite soon. And this European regulation also provides civil liability for violations, human rights violation within the supply chain. And therefore, I think Germany is really on the forefront of this development when it comes to supply chain. But I'm curious to hear what the Netherlands have done in this regard. So,
yeah, let me switch this over to Bart to talk a little bit about this issue of the violation of human rights. But before we end this topic, though, I do want to come back to one of the questions that was raised about validating and ensuring the authenticity of ESG data, because I think it's particularly difficult when you're dealing with the supply chain or these issues of the S component. It can be difficult for the E component as well. But I think we have much more developed in terms of monitoring and measuring and analyzing for the E part, less so on many of the social questions, and especially when these social questions get into supply chain aspects that are they're organized and governed by different countries, right? So you're not even dealing within your own system. So we did have a question come up about that, but let me turn to Bart and get his thoughts on the human rights issues.
Oh yeah, with regard to the supply chain, I think we have one big case recently on the supply chain, and that was with regard to a fashion company, G-Star, a Dutch fashion company, and it was held accountable, liable for an obligation pursuant to its towards its supplier, pursuant to its own corporate responsibility policy, which most companies have in place to be responsible for the supply chain. And then it was held accountable, and it was a very far-fetched obligation that it needed to pay a lot of money to fulfill some kind of obligation towards its supply chain in abroad in third countries. And that's what we see more further far-fetched as well, that supply chain is becoming more important, but it is already part of the legal discussion because it follows also from the UN principles on human rights and business, that you need to have some duty of care towards your supply chain. And the CSRD is already implementing that to a certain extent, and the CSDD will do that in a further extent, but also already the CSRD is making more obligations in that regard. So I think already the CSRD can provide a hook for claims in that respect.
Okay, and what about the issue of the data and being able to monitor and measure and analyze?
That's what we see a lot with clients. That question is a very good question. We advise clients on amending their corporate governance and their structures, and to put good data provision systems so that you have good checks and balances within the organization, and that your governance is good with ESG professionals, legal and communication, and also climate experts, to have that all in place so that you have all the good data at the good person to have the good risk management in place. So that's the new challenge of multinationals, to have good data and a good corporate governance in combination thereto. And you cannot stick to the old corporate governance structures as you had with separate legal and separate climate. You need to think about really holistic on this to have a good approach and risk management.
Yeah, and the challenge is even bigger if you work really international, because we have EU standards now in place. But when it comes to Asian countries, to the US, there are so many different kinds of reporting, and people find it so difficult to collect all the data and to implement it in their daily structure. I was at a panel discussion in the UK this spring, and heard so many UK people also complaining, because I mean they have a similar regime now or in place. It's coming up in place, but of course they also always have they have investment products in Luxembourg, in the European Union, so somewhere else. So you're affected everywhere in the world globally by this new reporting standards, if you work with Europe, if you work with the EU regulations. And I think this is a big challenge for the companies, and they're really struggling at the moment. And we try, of course, as Bart does, to assist them with building up their compliance system and the new governance.
Yeah. Okay. I think that we received a couple of questions that continue to touch on this tension, if you will, between the investing community and businesses that are producing goods and services. And one question that came up was, and this goes back to the case in Peru that you discussed, Sonja. Why isn't there a mutual obligation on the part of the government in Peru to ensure that there's compliance in environmental?
You can go to the first slide, because there is also the RW with the global chart on it.
Okay, yeah, can we go back to that?
There's also the Peru thing mentioned, because then you see really the global.
I think.
Here,
this
you
one,
see
this one.
yeah, because the RWE is really Peru, Germany, and then you see the wheel, that is a real global. Yeah, but sorry to interrupt.
No, that's okay. I mean, Sonja, do you want to add to that? Do you have more to say on that particular topic? Because it really does get into this tension of who's responsible.
Yeah, so I mean, the Peru case is really special because RWE doesn't even have factories in Peru or something, so it's so far away. So the question is really where the responsibility starts and where it ends. So I think in Germany we have a Climate Change Act and we have regulations which are force companies to comply with climate change, greenhouse gas emissions, with climate change goals and similar. And I think the companies, mainly all companies, they are in line with those regulations. So I mean, it's just what the judges and the courts say in Germany, that it's really the government who has to set the rules and to provide the laws. But as long as the companies are in line with the laws, they can't be held liable for a climate change infringement or something like this. So, I mean, this is more a political argument than a legal argument. But in Germany, it's common sense that only the legislator have to set the goals for climate change and not the courts. And this holds in particular because there are valid opinions who say that a company cannot be held liable further than the states that the state is set the frame. So from my perspective, this is quite clear. And of course, all the companies are really keen and they are really willing to comply with all those regulations, which get even more. I don't know if you're familiar with ESG. There is, I mean, every 1 or 2 weeks, another regulation coming up in Europe. So, I mean, it's the different.
And in the US.
Then US. I mean, Robin, we discussed that earlier. So, I mean, the US has another approach than Europe. But I think it's very hard for the even the state comply with all the EU regulations in a timely manner. We see that all the developments are sometimes too late because they can't be implemented within a reasonable period of time. And the same applies for the companies, which need to build up their compliance departments, and which is a big task and a big challenge for everyone. So I think Germany is really keen to cope with all that requirements, but of course there are always gaps and
Right.
which you need.
And I want to switch gears a little bit, but to bring out this very point. So when we haven't talked yet about the shareholder activism, and how that interacts with the pursuit of ESG goals and performance. So what are some of the really important trends that we're seeing there, and the different risks that are coming up for companies? And Sonja, I'll start with you because I think that you have a couple of slides that speak to this issue.
Yeah, absolutely. Thank you. So shareholder activism is, I think, one of the most hot topics in Europe, and it has increased a lot within the last 2 years. I think by 70%, if I know it right. Also, it's not directly a class action. I think it's worth mentioning here because, I mean, if they are NGOs bringing claims for so many individuals before the courts, and with regard to litigation, it's always that what Bart mentioned before, that the NGOs who bought their stakes in the company is now sued, in particular the director, for wrong management decisions and for not coping with ESG standards, which the company maybe should have coped with. And Germany is not on the very forefront of this development recently. So UK was a big target of shareholder activists in the last years. France as well. Germany not so much anymore. And this is why I highlighted 2 cases. One is the Client Earth versus Shell Board of Directors decisions. So NGO Client Earth, they filed a claim against the Shell directors because they were not, let me say, satisfied with the climate change risk management strategy of the management. And according to Climate Earth, the Shell's board of directors was not moving away from fossil fuels quickly enough, and thus would risk the company's long-term viability. So the High Court dismissed the case in 2023, but granted Client Earth an oral hearing to make their case anyway. So this is still an ongoing proceeding, which is of big interest all over in Europe. And maybe
well, one of our participants asked whether or not if this were to happen in the Netherlands or Germany, would the outcome or rationale differ? And so first, Sonja, you respond, and then I'll let Bart respond to that.
Don't know, because such kind of derivative claims which are brought in the UK are just not possible in Germany. So I think it's not a mean which you can use in Germany. What you can use is you can claim as an individual to bring an action against maybe the management body or so, but those kind of derivative claim which were possible in the UK are not possible in Germany at all. And yes, if you ask a more general perspective, of course, we expect that such actions will be brought also before the German courts in the near future, because I mean, ESG litigations is really at the beginning in Germany. We have this very prominent cases with the automotive manufacturer, but only less cases. Why? Because we haven't established class actions yet, because ESG is just in the beginning of the development in Germany, and we expect to see so many actions from all parts of the topics we discussed within the last hour coming up in Germany in the next, let me say, 2-3 years. but this is only a forecast, which we think is really highly likely. And in particular, you see it if you consider all the requests and for advice of clients from all different branches, and to see that there is a big interest and a big issue on this topic in general.
Okay, so Bart, what would be different in the Netherlands?
Yeah, first to touch upon the shareholder activism, still a little bit, because I think Netherlands is a little bit in the forefront of that, because we see shareholder activism is a really hot topic in the Dutch and the European boardrooms here, because a lot of institutional investors are using this mechanism to have impact on the strategy and dismissals of board, remunerations of board, and even now. Organizations are buying actively a lot of shares to even influence those institutional investors, and they have success in it. So they have a success in. So the follow this is a really important example of that. So they buy shares and then they go influencing stakeholder management with big institutional investors to get them on board, to have them on board for long-term ESG matters on remuneration, strategy, and the dismissal of board. So, and they're really successful, for example, at Shell in that, to have some kind of changes in the strategy. So that is the shareholder activism part. That's not really litigation, but that's really influencing with your corporate legal possibilities. And next to that, the derivative actions. I would mainly think security litigations like pursuant to the CSRD in the Netherlands coming up. That's really what I expect, and what also the Dutch legal society expects, which to come up shortly after all companies have been transparent about their climate plan and moving forward.
So a question came up that I see is related to this, because with the shareholder activism and let's say companies then are responsive and then put into place various programs. One of the participants asked, how do we validate these programs and transactions and various other things that we might spend to enhance ESG performance? How would you make sure that doesn't become a new area for misleading or fraudulent activity? So do you have any thoughts about how we will balance?
Yeah, that's always the challenge in these kind of situations when new rules coming up. All accountants are now diving on this new business for the ESG compliance. But I think there's not a lot of choice for multinationals to just walk the line and to substantiate as good as possible that you are ESG compliant and that you have a good transition plan in place. I was on a big forum also for NGOs in Oxford last week, and digitally, and I heard a lot of some person who were being there that the climate transition plan is on the top of the agenda now of the NGOs. They are checking all the climate transition plans. So that is what the focus is on. So yeah, even if there is some abuse of this kind of ESG processes in place, better to have to more than the less, I think, in this respect. But please beware of the quality of the system. So I would look really good into the quality.
Yeah. Okay, Sonja, any thoughts on that? Because I think that's a huge issue if you have active shareholders, including NGOs, that are going to be pushing for certain activities. How will that all, one of the most important issues here in ESG is being able to substantiate the actions and the operations and the planning and the programs that are being implemented. So that it seems to me this creates a new tension.
It creates a tension, but if you do what you can do, because sometimes you're limited by by regulations of the government or by the possibilities the market provides. For example, the supply chain is completely disrupted due to the Ukraine crisis. Inflation is going high, and also the energy transition of the government is not going that fast as promised. So you're also, as a company, limited to that limitations. So you need to explain that. And if you can explain why you are limited in your ESG targets and goals, then I think you should be on the safe side, because you cannot win a Formula One on your bike. So
unless you do business in the U.S., and then you're not at all protected. Okay, but let Sonja respond to that a little bit. Go ahead.
No, but I can fully agree with Bart there. I have nearly nothing to add here, because he mentioned all the important aspects. I mean, the key issue in Europe is it's also a political debate, and the legal actions are following this political debate. So companies just have to be prepared that even those abusive actions will come up. You cannot avoid this, because I mean, it's just a trend, and the NGOs are pushing really hard in Germany on the politics, on the legal market, everywhere, to bring those kind of actions. And from my perspective, to be compliant, to collect the data in a correct way, to monitor, to report, to have a reporting which is in line with the legal requirements, is the key issue what you can do here. And you just cannot avoid kind of shareholder activism or other claims, directors' liability claims coming up in the next years. This will just happen. And even if you're fully compliant, if you do everything right, there is this risk, which is a financial risk, a reputational risk. It can be a bad the company risk. So, I mean, it's really important to have a big focus on those issues. But I cannot add more on this, as Bart already mentioned.
Yeah. Okay. And someone raised an issue of having something like an ESG havens, in the sense that if you comply and you provide all the information, you make the disclaimers, then you shouldn't have to have either penalties or perhaps they were mentioning that the restrictions would be lighter, but I think the main issue is, and we have this in the United States. So if you, for example, are making claims about a product's, the environmental consequences of the product, and then you put in appropriate disclaimers, it's supposed to mean that you're not misleading, but that does not in any way stop class action lawsuits. And again, in the United States, we have something like 10,000 a year. So we're very experienced with class actions. But do you think it makes sense that there, as part of all this regulation, does it make sense that there would be then some accommodation for really being in compliance and being forthcoming and putting out information such that then the courts wouldn't allow various actions against you to go forward? So Bart, it looks like you want to respond to that. Go ahead.
Yeah, I think this is a really good question, Bekir, because I think this is exactly what will happen. Because if you are ESG compliant, because all banks and financing institutions will also look at ESG risks of its companies. So if you are ESG compliant, you will get easier financing. And also insurance companies will look at that, because on the long run, certain activities are not insurable any longer. You see in the United States, Robin, you're in the United States, you know that some oil and gas companies are being rejected from insurance policies. So on the long run, the screws are being turned to from finance and insurance, and also tax. You, of course, if you have green financing, you also get tax benefits on that. So everything is being benefited for for ESG, being ESG compliant. So, but I think Sonja also some interesting points on this aspect.
Yeah, maybe I would like to highlight another point. I come from the different direction because, I mean, the problem is not only if you are compliant or not, but there is a whole litigation industry and also litigation funders behind all those class actions and all behind all those development. And it's a real industry. They are working like we work. So the problem is they also want to make money, and so it will be still ongoing. In Germany, we don't have a mechanism that some claims are not admissible just because you are compliant or you think you are compliant. These claims will just come over you, and then you have to defend yourself. Even if you're compliant, then maybe you win the action, but there is no way that you can escape such claims in courts. So I think you just need to be aware. It's like with all the diesel cases. I mean, with the thousands of those cases which are driven by really a litigation industry, and they came from mass actions with regard to banking lawsuit. Then they moved over to the manufacturers, to the car industry. So they need a new playground in the near future, and I'm pretty sure that this one playground will be the ESG field. So, I mean, we need to be aware of this, and so I think we need to handle it. At least from a German perspective, there are no ways to avoid actions. There are just ways to defend the actions. Of course, you can avoid actions if you maybe negotiate or talk to these guys before they file a lawsuit, but from a litigation mechanism, there is nothing you can do against that.
Yeah, your last point is specific, Sonja, was a very good point. The stakeholder management with the NGOs to get into discussion, to talk. I think I would always advise that as your last part of your risk management or crisis management, to have good contacts with all the stakeholders, amongst which the NGOs, to explain what you're doing and that you're doing the utmost what you can do to be in the transition in a positive way. And in that way, you can avoid perhaps some extent of the ESG claims coming towards your company.
Okay. I think that we have addressed most of the questions that have come up. But I have again, because I am in the US, I will ask a little bit different question now. And I'm sure that you're quite aware that in the US, there's now a tremendous backlash to many of the core concepts of ESG. I think you see it on the environmental front, especially when it gets into the tension about fossil fuels versus alternative sources of energy. But you really see it on the social front when it comes into play about diversity and having any kind of affirmative action programs. I mean, this is where we are seeing a tremendous backlash. And I'm wondering whether or not you think the backlash in the US is going to affect the growth of class actions related to ESG in Europe. Do you think we were leads on class actions regarding ESG when there was a big push for it? Are we going to be leaders when there is a backlash against it? So go ahead, Bart. Why don't you respond to that?
Yeah. Of course, there was also in Europe a small backlash in this regard, but I think class actions will rise because it is also dependent with the causal connection with the acceleration of climate change. So I think last years the climate change really accelerated throughout Europe. We have all kinds of forest fires, heat waves, and things like that, and that accelerates all kinds of activism. In the Netherlands, all week in the main city of where the government is sitting, all kind of extinct rebellion is really activistic. And all kind, so we see a lot of activism last month. So I don't see a backlash at this moment. I see the opposite now: more activism, more extreme activism, and also preparation for further lawsuit. But that's also connected to the acceleration of climate change.
And
okay,
And we just cannot turn the wheel back in Europe. I think we are we've come too far with all the new regulations, with all the new compliance systems, and I don't think that it's just easy to turn if someone would turn the wheel back. So I don't think that was happen.
Okay. Well, we have just about reached the end of our time, but Bart, did you have something else you wanted to add?
No,
Okay.
no. Thank you for your time. Yeah, be prepared for and stay on top of the knowledge on this aspect, because as Sonja said, regulations are changing every week almost. So it's good to have somebody dedicated in your organization to keep this knowledge up to speed and have a good crisis risk management and crisis management in place globally to tackle this problem, and work with multidisciplinary teams. Look at your governance holistically, and from there you can act and you can get this challenge to a good solution for your company.
Okay. All right. So first, I want to thank Bart and Sonja for just wonderful thoughts and comments and contributing here. And now I'm going to turn it over to Rob.
Thank you, Robin. And that was good, wasn't it, everyone? But I suppose that's what's happened when you gather three of the finest minds in the business under one virtual roof. And if that's whetted your appetite for informative, intelligent, and insightful conversation about class actions, please do join us at the Global Class Actions Symposium in London, either virtually or in person. It's in beautiful Covent Garden and a lovely time of the year on the 13th of November. In the meantime, thanks to everyone from all around the world who joined us, especially those who took the time and trouble to ask questions. But most of all, my profound thanks to Dr. Robin Cantor, to Sonja Hoffmann, and to Bart-Adriaan de Ruijter for taking the time to join us today. Thanks so much, guys.
Okay, well, thank you.
Thank you.
Thank you all.
Have a wonderful day. Bye.
Bye-bye.